I am not a janitor. I never was.
Caldwell County Courthouse had gone through 6 janitors in 11 years, and nobody who worked there had ever bothered to learn why. The turnover was written off as the kind of thing that happens with low-paying custodial work, nothing more. When a woman named Doris Malone started that January, carrying a mop bucket and a laminated badge with a photograph that made her look tired in exactly the way real exhaustion looks, nobody in that building gave her a second thought. She was in her mid-50s, gray threading through dark hair she kept pulled back, wearing the same Navy County-issued polo every day, moving through the halls with the particular invisibility that comes to people whose job is to clean up after everyone else. Nobody remembered her name for the first 3 weeks. That was exactly the point. Doris Malone did not exist. The woman wearing her badge was named Vivian Marsh, and she had spent 19 years as a federal investigator with the Department of Justice Civil Rights Division before she ever picked up that mop. Vivian had taken this assignment after 8 months of complaints had piled up in a federal intake file that almost nobody read closely enough to notice the pattern buried inside it. Bail amounts in Caldwell County ran nearly 4 times the state average for identical charges. Public defenders rotated out of the county courthouse faster than any other jurisdiction in the region, several of them citing reasons vague enough to raise flags on their own. A bail bond company called Holloway Surety Group held what looked, on paper, like an unusually large share of the county's bond business, and it took exactly 1 afternoon of searching public records for Vivian's supervisor to discover that the company's registered agent shared a last name with the presiding judge of Caldwell County's criminal docket. Coincidences like that did not survive scrutiny in Vivian's line of work. She had asked for this assignment herself, against her supervisor's mild objection that undercover custodial placement was an unusual approach for a woman 2 years from a desk job. Vivian had told him that sometimes the only way to hear what a building was actually saying was to become furniture in it. Judge Gordon Holloway had presided over Caldwell County's criminal docket for 16 years, a broad, silver-haired man with a laugh that carried through his chambers and a reputation, outside the county, for being tough but fair. Inside the county, among the people who actually appeared before him, the reputation carried a different weight entirely, though almost none of them said so out loud, not to reporters, not to lawyers, not to each other. Fear has a way of making silence look like consent. District Attorney Bill Reyes worked in a kind of easy partnership with Holloway that neither man ever needed to name directly, an understanding built over 16 years of the same docket, the same courtroom, the same rhythm of plea deals pushed through faster than they should have been, and bail amounts set high enough to guarantee a bond company's business. Vivian's first 3 weeks on the job were spent doing exactly what a janitor does: emptying trash cans, waxing floors after hours, and listening to every single word said within earshot of a mop bucket that nobody in that building thought to lower their voice around. The courthouse had a particular architecture of forgetting. Attorneys spoke freely in hallways because hallways felt like nowhere transitional spaces between the rooms that actually mattered. Vivian understood this instinctively, the way she understood most things about how people behaved when they believed no one worth noticing was listening. She learned in her second week that the woman who ran the courthouse cafeteria had watched 3 separate public defenders quit within 18 months, each one citing burnout, though the cafeteria woman, whose name was Sherry, had her own theory that had nothing to do with burnout and everything to do with what happened to lawyers in that county who pushed too hard against a plea deal Judge Holloway had already decided on before the hearing began. Vivian wrote none of this down where anyone could find it. She had learned over 19 years to carry information the way she carried a mop, as something ordinary, something nobody looked at twice. By her 4th week, Vivian had identified a bailiff named Ray Coben as the closest thing the courthouse had to a conscience, a heavy-set man in his early 60s who had worked security in that building for over 2 decades, and who had developed, in that time, a habit of doing small, quiet kindnesses for defendants that cost him nothing and meant everything: holding an elevator, offering a bottle of water, speaking gently to a mother crying in the hallway outside Courtroom 3. Ray did not know what Vivian actually was, and she had no plan to tell him. Not yet. Not until she understood exactly how far his willingness to help might extend once the truth of the building became something he could no longer avoid seeing. She had learned, in her career, that good people trapped inside broken systems often knew far more than they allowed themselves to consciously admit, because admitting it meant they would have to do something about it, and doing something about it, in a county like this one, could cost a person everything they had built. The bail bondsman himself, a man named Curtis Halloway, was the judge's brother-in-law, and he ran his office 2 blocks from the courthouse in a storefront with tinted windows and a neon sign that never quite turned off completely, even in daylight. Vivian had photographed the building from across the street on her second Saturday, standing at a bus stop with a phone held low against her hip, the way tourists photograph things they think no one is watching them photograph. She had pulled his business filings from the county recorder's office on her lunch break, using library computers 3 towns over, never the same branch twice, never her real name attached to a single search. Curtis Halloway's bond company wrote bail for nearly 60% of Caldwell County's criminal defendants, an astonishing figure for a county that size, and every single one of those bonds ran through a courtroom presided over by his own brother-in-law. Vivian had seen corruption built on far less obvious architecture than this. What made Caldwell County unusual was not the scheme itself. It was how completely unbothered everyone involved seemed to be about anyone ever noticing it. Jordan Ellis was 19 years old when a Caldwell County detective named Frank Doyle pulled him over 3 blocks from his mother's house for what the report would later describe as a broken taillight, though the taillight, as it happened, worked perfectly fine. What Doyle found in the glove box, according to his own sworn account, was a small bag of a substance later confirmed as cocaine, an amount just large enough to qualify as intent to distribute rather than simple possession, a distinction that carried enormous weight in how the case would be charged, and more importantly, how high the bail would be set. Jordan told his public defender, a young and clearly overwhelmed attorney named Priya Anand, that the bag was not his, that he had never seen it before, that Doyle had reached into the glove box himself before showing it to him, and that none of it made any sense given that Jordan had spent the entire evening at his cousin's birthday dinner with 14 witnesses who could confirm exactly where he had been. Priya believed him. Priya also understood, within her first 2 months working Caldwell County's docket, that belief and outcome rarely traveled together in that courtroom. Vivian first noticed Jordan's case the way she noticed most things that mattered, sideways, through a conversation she was not meant to overhear. Jordan's mother, Carla Ellis, worked the overnight shift at Caldwell Memorial Hospital and had taken an unpaid leave day to sit through her son's bail hearing, sitting in the 3rd row in scrubs she had not changed out of, twisting a paper program in her hands the way people twist things when their hands need somewhere to put the fear their face is working hard to hide. Vivian was mopping the hallway outside Courtroom 3 when she heard Carla ask Sherry, in the cafeteria line an hour earlier, whether she thought $200,000 bail made any sense for a first offense with no prior record, and whether there was anyone in that building who might actually listen if she tried to explain that her son had never once been in trouble before that night. Sherry, kindly and honestly, told her that in Caldwell County, listening was not really something the building was built to do. Judge Halloway set Jordan's bail at $220,000, an amount that guaranteed, with mathematical certainty, that Curtis Halloway's bond office 2 blocks away would collect a premium Carla Ellis had no realistic way of affording without remortgaging a house. She had already refinanced twice to pay medical bills from her husband's illness years earlier. Priya's objection that the amount was wildly disproportionate to the charge, and that Jordan had strong community ties and no flight risk whatsoever, was overruled in under 90 seconds, with Holloway nodding for the record that drug offenses in his courtroom carried consequences regardless of an attorney's characterization of her client. Vivian stood in the hallway outside, mop resting against the wall, and watched Carla Ellis walk out of that courtroom holding herself together with the particular effort of a woman who had decided, somewhere along the way, that falling apart in public was a luxury she could not currently afford. Vivian recognized that walk. She had built a career noticing exactly that walk in exactly that hallway, in courthouses across 4 different states. What Vivian needed, and what she had not yet found in 4 weeks of quiet observation, was documentation, something beyond pattern and instinct, something a federal prosecutor could actually build a case around. Patterns convinced investigators. Patterns did not convict judges. She needed financial records connecting bail amounts directly to bond commissions, needed proof that Holloway and his brother-in-law coordinated rather than simply happened to benefit from a system that looked corrupt only if you squinted at it from exactly the right angle. She found her opening in the courthouse records room, a windowless space in the basement that the 6 janitors before her had apparently avoided entirely, judging by the layer of dust across file boxes nobody had touched in years. Vivian had requested basement duty herself, framing it to her supervisor, a tired county facilities manager named Gary who barely looked up from his crossword, as a simple preference for quieter work away from foot traffic. Gary had shrugged and handed her the keys without a second thought. The records room held 11 years of case files in cardboard boxes stacked according to a filing system that made sense to nobody who had not personally created it, though Vivian had spent enough years combing through disorganized evidence to recognize a pattern within an hour of searching. She began cross-referencing bail amounts against bond company names, working in small stretches during her lunch break, and after hours when the building had emptied, photographing pages with a phone she kept in her sock, transferring images each night to an encrypted drive she mailed weekly to a federal post office box 3 counties away rather than risk carrying it on her person. The pattern, once she had enough data points to see it clearly, was almost elegant in its consistency. Every bail amount set above $100,000 in Holloway's courtroom over the past 4 years had gone through Curtis Holloway's bond office. Every single one. Defendants who could pay cash bail outright, avoiding the bond company altogether, were vanishingly rare in that courtroom, not because Caldwell County's defendants were unusually poor, but because Holloway's bail amounts were calibrated with startling precision to sit just above what most families could pay outright, and just low enough that a bond premium felt survivable by comparison. It took Vivian 6 more weeks to find what she actually needed, a set of handwritten ledger pages tucked inside a shipping box in the corner of the records room that had nothing to do with case files at all, notes in a handwriting she matched, through careful comparison with signed court orders, to Judge Holloway himself, tracking monthly bond company revenue alongside dates that corresponded almost perfectly with sentencing hearings. She photographed every page twice, her hands steady in a way that surprised even her, given how many years it had been since a discovery like this had actually made her pulse change. She mailed the images that same night. 2 days later, her supervisor called the burner phone she kept for exactly this purpose and told her, in the flat, careful voice federal investigators use when something has stopped being theoretical, that the Bureau was opening a formal financial investigation, and that Vivian needed to stay in place long enough to corroborate the ledger with something that could not be dismissed as circumstantial. Corruption, Vivian had learned across 19 years, rarely announced its own unraveling. It simply grew slightly more careful, in small ways that told you someone had noticed being watched without knowing exactly who was watching. The first sign came from a courthouse clerk named Denise Lauro, a woman in her 40s who had worked directly under Judge Holloway for 9 years, and who Vivian had clocked early on as someone whose loyalty ran less toward the law and more toward whoever signed her performance reviews. Denise had begun, in Vivian's 7th week, asking small questions that carried more weight than their casual tone suggested, wondering aloud why the new janitor spent so much time in the records room, wondering whether Doris had worked in any other county courthouses before this one, wondering, once, directly to Vivian's face with a smile that did not reach her eyes, whether Doris found the basement files interesting reading material. Vivian had prepared for exactly this moment before she ever put on the navy polo, a full-cover history built with the same care federal witness protection uses, a fabricated employment record with 2 prior custodial positions in counties 2 states away, both confirmed by real phone numbers connected to real people who had been briefed and paid to answer exactly the right way if anyone called checking references. She told Denise, with the mild embarrassment of someone caught doing something slightly odd rather than something dangerous, that she found the old files interesting because her late husband had been a paralegal, and that reading through old cases reminded her of him. It was a lie built from a small true fact, that Vivian's actual late husband had in fact been a paralegal decades ago before he passed. She had learned that lies built on a splinter of real grief tended to survive scrutiny far better than lies built from nothing at all, because grief made people uncomfortable enough to stop asking follow-up questions. Denise seemed to accept it, though Vivian noticed, over the following 2 weeks, a subtle increase in how often Denise found reasons to walk past the records room, and a subtle decrease in how freely people spoke in hallways when Vivian's cart was nearby. Somebody, somewhere in that building, had begun exercising the kind of caution that suggested a low-grade suspicion rather than confirmed knowledge, and Vivian understood that this was the most dangerous phase of any undercover placement, the point where a target grows careful without yet growing certain, because careful people sometimes acted rashly to eliminate a doubt before it became a threat. She called her supervisor that week and told him the window was narrowing, that whatever corroboration the Bureau needed beyond the ledger, they needed to move toward it faster than originally planned, because she no longer trusted that she had months left in that building. She was right to worry. She had, in fact, considerably less time than she thought. Before we dive deeper, let us know in the comments where you're watching from. We'd love to hear from you. And don't forget to hit that subscribe button so you never miss any of our upcoming videos. The corroboration came from an unlikely source, a burner phone Curtis Holloway kept for communication with his brother-in-law, that a cooperating former employee of the bond office, a young man named Miguel who had quit 2 months earlier after growing uneasy with what he'd been asked to help falsify, had agreed to describe in detail to federal investigators once Vivian's ledger evidence gave the Bureau enough leverage to approach him without spooking Curtis Holloway into destroying anything. Miguel could not access the phone directly, but he remembered enough about Curtis Holloway's habits, including a standing Thursday evening call placed from the bond office to Judge Holloway's personal cell phone, a call Miguel had once overheard by accident and never forgotten, because of a single sentence that had stayed with him for the 2 years since. Curtis Holloway had said, laughing, that between the two of them they'd turned a broken tail light into a down payment on a boat, and Judge Holloway had laughed back. With Miguel's account corroborating the pattern in the ledger, federal prosecutors secured a wiretap authorization on Curtis Holloway's business line, a process that took another 11 days of legal preparation, while Vivian continued mopping floors and emptying trash, cans with the same unremarkable patience she had maintained for months, giving no outward sign that the walls around her were about to start talking in a way that would end everything. The wiretap captured 6 weeks of conversation before federal agents determined they had enough. Conversations in which Judge Holloway discussed upcoming bail amounts before hearings had even taken place, coordinating numbers with Curtis Halloway in language careful enough to avoid explicit admission but specific enough, combined with the ledger and court records, to leave prosecutors confident a jury would understand exactly what they were hearing. One recorded call, made the same week as Jordan Ellis's bail hearing, included Judge Halloway telling his brother-in-law that a new case was coming through worth setting high, a young man with no record but a mother who worked nights and would not have the resources to fight it. He had not used Jordan's name. He had not needed to. The timing left no ambiguity at all. Vivian read the wiretap summary the night it was delivered to her through the same encrypted channel she had used for months, sitting alone in the small rented room she called home during the assignment, and felt something she rarely allowed herself to feel this early in a case, a settled certainty that the pieces had finally locked into place completely. She thought, reading Halloway's words about Jordan Ellis, about Carla Ellis twisting a paper program in her hands in the third row of that courtroom, about a 19-year-old with no record sitting in a cell his family could not afford to release him from, about how casually two men had discussed the calculated cruelty of it over a phone line neither of them imagined anyone was listening to. She called her supervisor the next morning and told him she was ready. He told her the timeline had accelerated. Jordan Ellis's sentencing hearing, the final step before a plea deal Priya Anand had fought and lost against for months would become permanent, was scheduled for the following Tuesday. If they were going to act, it needed to happen in that courtroom in front of everyone before the deal became irreversible. Tuesday morning arrived cold and gray, and Caldwell County Courthouse opened its doors exactly the way it had every morning for 16 years, with no outward sign that anything unusual was about to unfold inside it. Vivian arrived early, as always, pushing her cart through the same hallways she had cleaned for 4 months, though this time 3 federal agents in plain clothes sat scattered through the gallery of Courtroom 3 before the session began, indistinguishable from ordinary spectators to anyone who did not know to look for them. Carla Ellis sat in the third row again, in the same seat, wearing the same worn cardigan she had worn to every hearing since her son's arrest, her hands folded the way they always were, bracing herself for an outcome she had been told, by an overworked attorney doing her genuine best against an unwinnable system, was essentially decided already. Jordan sat at the defense table in an orange jumpsuit that had become, over 4 months, a kind of second skin he had learned to wear without flinching, though something in his eyes that morning still carried the particular disbelief of a young man who could not fully accept that this was actually his life now. Judge Halloway took the bench at 9 o'clock exactly, the same unhurried authority he always carried, calling the docket in the same practiced rhythm, working through 2 earlier cases before reaching Jordan Ellis's file. He accepted the plea agreement's final terms from District Attorney Reyes with the same easy familiarity the 2 men had shared across 16 years of shared docket, and he turned to Jordan to begin the formal allocution that would make the sentence permanent, the moment after which nothing Priya Anand or anyone else could do would undo what had been set in motion, the night Frank Doyle pulled over a car with a tail light that worked perfectly fine. It was at this exact moment, as Judge Halloway asked Jordan whether he understood the rights he was giving up by accepting the plea, that Vivian Marsh set down her mop against the back wall of the courtroom, walked to the center aisle, and asked, in a voice that carried without needing to be raised, whether the court would permit her to make a statement before the hearing continued any further. Judge Halloway looked at her the way he had looked at every janitor before her, which was to say barely at all, and told her, with visible irritation, that custodial staff had no standing to address the court during an active proceeding. Vivian reached into the pocket of her navy polo and produced a federal credential, holding it up not toward Halloway but toward the room itself, and said, in the same calm voice, that her name was not Doris Malone, that she was a federal
I am
investigator
not a
with the
janitor.
Department of
I
Justice
never
Civil
was.
Rights Division, and that she had spent the past 4 months documenting a pattern of coordinated financial misconduct between this courtroom and Holloway Surety Group. The 3 men and 1 woman seated scattered through the gallery rose simultaneously, credentials of their own now visible, moving with the unhurried authority of people who had rehearsed this exact moment and knew precisely how it needed to unfold. Judge Holloway's face went through several things in rapid succession: confusion, disbelief, and finally something that looked almost like recognition. The particular expression of a man realizing that a woman he had spoken past for 4 months without ever once truly seeing her had, in fact, seen every single thing about him. The courtroom did not erupt the way courtrooms do in dramatizations built for entertainment rather than accuracy. It went, instead, almost completely silent, the particular silence of a room full of people trying to recalculate everything they thought they understood about the last several minutes, the last several months, the last 16 years. District Attorney Reyes rose halfway from his seat and then sat back down, apparently deciding, in real time, that standing up drew more attention to his own position than remaining seated. Priya Anand turned in her chair to look at Vivian with an expression that moved, within seconds, from confusion to something that looked almost like relief, so profound it bordered on physical pain. The specific relief of a young attorney who had spent months believing she was failing her client through some deficiency of her own skill, only to learn the entire system around her had been rigged in ways no ordinary defense could have overcome. Vivian addressed the court directly then, laying out, in plain and unhurried language, the pattern the Bureau had spent 4 months and before that, 8 months of complaint review documenting, the disproportionate bail amounts, the financial ties between Judge Holloway and Holloway Surety Group, the wiretap recordings, including the specific recorded conversation from the week of Jordan Ellis's arrest in which Judge Holloway had discussed, with his brother-in-law, setting bail high for a young man with no record and a mother working nights who would lack the resources to fight it. She did not raise her voice at any point. She did not need to. The specificity of what she said carried its own weight into every corner of that courtroom, landing hardest, though she did not look at him directly while she said it, on Judge Holloway himself, who sat behind his bench with his hands flat against the wood surface. The exact posture, though nobody in that room would have made the connection, of a man discovering the floor beneath him was no longer solid. Judge Holloway was taken into federal custody that same afternoon, escorted from his own courthouse in handcuffs through the same hallway Vivian had mopped for 4 months, past the same cafeteria where Sherry stood frozen behind the counter, past the same records room where the ledger that ended his career still sat inside its cardboard box waiting to be formally entered into evidence. Curtis Holloway was arrested within the hour at his bond office, the tinted windows and the neon sign still glowing when federal agents arrived. District Attorney Reyes was placed on administrative leave pending a full review of his own conduct, a review that would, over the following months, uncover a pattern of his own complicity extensive enough to end a legal career that had once seemed unassailable within Caldwell County. Jordan Ellis's plea agreement was vacated that same day. The charges against him dismissed entirely, once a federal review of Detective Frank Doyle's original traffic stop revealed inconsistencies serious enough to raise their own separate investigation into the arrest that had started all of it. Carla Ellis did not fully understand, in the first several minutes after Vivian's credential appeared, exactly what was happening in front of her. She understood only that the woman she had passed in that hallway dozens of times over 4 months, the quiet janitor who had once, without explanation, brought her a cup of coffee on a morning when Carla had arrived too early and too exhausted to think of getting one herself, was not who she had believed her to be, and that whatever she actually was, it had something directly to do with her son. She sat in the third row with her hands still folded, watching agents move through the room with the calm efficiency of people executing a plan rehearsed many times before, watching Judge Holloway rise from his own bench for the last time, watching her son's attorney turn toward Jordan with tears she made no effort to hide. It was Ray Coben, the bailiff, who finally crossed the room to where Carla sat, kneeling slightly beside her chair the way he had done for other frightened family members across 2 decades of working that courthouse, and told her, in a voice gentle enough to reach only her, that whatever had just happened, it looked like her son was about to go home. Carla did not cry immediately. She sat very still for a long moment, the same stillness she had carried through every hearing since the arrest, and then she turned to look at her son across the room, and Jordan looked back at her, and something in both their faces broke open at exactly the same time, the particular release of 2 people who had spent 4 months bracing for the worst outcome imaginable, finally understanding that they did not have to brace anymore. Jordan crossed the room the moment the marshal removed the restraint from his wrist, and Carla stood to meet him, and the 2 of them held onto each other in the middle of a courtroom that had, until roughly 11 minutes earlier, seemed determined to take him away from her for years. Vivian watched this from where she stood, credentials still in hand, and allowed herself, for the first time in 4 months, something that was not quite a smile but sat somewhere adjacent to one. She had built a career on the belief that most corruption survives not through cleverness, but through the simple, exhausting fact that most people lack the time, resources, or standing to prove what they already know to be true, and she had spent 19 years trying to be the exception to that exhaustion for people who had run out of other options. She did not need Carla Ellis to know her real name for the moment to matter. She needed Carla Ellis to get her son back. Everything else, the credential, the wiretap, the ledger, the 4 months of navy polos and mop buckets, had only ever been the mechanism. The point, as it had always been the point, was the 2 people standing in the middle of that courtroom holding onto each other like neither one intended to ever let go again. The federal indictments came 6 weeks later, 22 counts spread across Judge Holloway, Curtis Holloway, and District Attorney Ray's, covering wire fraud, honest services fraud, and conspiracy charges built on a foundation the ledger, the wiretap, and Vivian's 4 months of documentation had made close to unassailable. Judge Holloway's attorney attempted, in the weeks leading up to trial, the same defense his client had once relied on in his own courtroom, a claim that bail decisions reflected legitimate judicial discretion rather than coordinated financial motive, an argument that collapsed almost immediately once prosecutors played the recorded call in which Holloway had joked with his brother-in-law about turning a broken taillight into a down payment on a boat. The jury deliberated for 6 hours before returning guilty verdicts on every count against all 3 men, a result that made the front page of a newspaper Caldwell County had not seen run a story about its own courthouse in over a decade. Vivian testified at the trial as herself for the first time in months, seated in a witness chair rather than pushing a mop cart, describing for the jury the 4 months she had spent as Doris Malone, the records room, the ledger, the careful architecture of a corruption scheme built to survive exactly the kind of casual scrutiny most people never thought to apply to a courthouse they assumed, by default, deserved their trust. She did not dramatize any of it. She answered questions plainly, the same steady patience she had carried through 4 months of emptying trash cans and waxing floors, because she understood from 19 years of doing this work that plain, careful truth carried more weight in a courtroom than performance ever could. Judge Holloway received a sentence of 11 years in federal prison. Curtis Holloway received 9. District Attorney Ray's, who cooperated in exchange for a reduced sentence, received 4 years and a permanent disbarment that ended a legal career he had spent decades building on the exact partnership that eventually destroyed it. Priya Anand left private practice within a year of the trial, taking a position with the state's Public Defender Oversight Office, specifically created in response to the Caldwell County scandal, an office tasked with monitoring exactly the kind of bail disparities that had gone unchecked in that courthouse for over a decade. She credited Vivian, in a local interview she gave reluctantly and only once, with restoring her belief that the work she had chosen still meant something, even in a system that had nearly broken that belief entirely during her first 2 years practicing in Caldwell County. Denise Lauro, the clerk whose growing suspicion had nearly ended Vivian's placement early, was found, in the subsequent investigation, to have had no actual knowledge of the financial scheme itself, only an instinct for protecting her employer that had outrun her judgment. And she kept her job, chastened, working now under a court administration entirely rebuilt from the ground up under federal oversight. 18 months after the trial concluded, Vivian Marsh sat in the gallery of a different courtroom, in a different county, wearing her own clothes for the first time in longer than she cared to calculate, watching Jordan Ellis walk across a stage at a community college graduation ceremony held in a gymnasium 2 towns over from Caldwell County. Carla Ellis sat beside her, no longer in scrubs, no longer twisting a paper program in her hands, watching her son accept a certificate in criminal justice, a field he had chosen. He told Vivian afterward with a small, careful laugh, specifically because he wanted to understand exactly how something so broken could still occasionally be fixed by someone willing to look closely enough. Vivian had not planned to attend. Carla had called her 3 weeks earlier, the first call between them since the trial had ended, and asked, simply, if she would come. Vivian had spent 19 years building cases that dismantled corruption piece by careful piece, ledger by ledger, recorded call by recorded call, and she had learned across all of it that the actual repair, the part that mattered most, never happened in a courtroom at all. It happened afterward, in gymnasiums and kitchen tables and quiet mornings where a family finally exhaled for the first time in months, in moments nobody photographed and no indictment ever mentioned. She watched Jordan cross that stage, watched Carla's hand come up to cover her mouth the way hands do, when a feeling arrives too large for a face to hold on its own. And she thought, not for the first time, about the exact moment 4 months into her assignment when she had set down a mop against the back wall of a courtroom, and picked up, instead, the only tool that had ever actually mattered in that building, the plain, unglamorous truth that somebody had finally been willing to spend the time proving. Justice, Vivian had come to understand across a career built on patiently gathering the evidence other people were too exhausted or too frightened to gather themselves, rarely looked like the moment it was delivered. It looked instead like everything that came after, a young man walking across a stage in a gymnasium 2 towns over, a mother no longer twisting anything nervously in her hands, a courthouse rebuilt under oversight strict enough that the next Caldwell County would have to work considerably harder to exist at all. She had worn a stranger's name for 4 months to make this exact moment possible, and she understood, watching it unfold from a folding chair in the 3rd row, that she would do every single day of it again without hesitation. Because some truths were worth exactly that much patience, and this had been one of them. If this story stayed with you, subscribe and stick around. We tell more stories like this one every week.